Gun control groups continue to outraise the NRA ahead of the election. Plus, a federal appeals court deals another blow to the gun ban for marijuana users. All this and more on the news update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome back to the news update. I'm contributing writer Jake Fogleman, joined as always by Reload founder Stephen Gutowski. TheReload.com, of course, is where you can head on over today and sign up for our free weekly newsletter to keep you up to date on all things going on in the world of gun politics and policy. This week, we want to lead off with the latest update from the FEC on the fundraising totals for all of the various gun groups, as we're getting very, very close to election season. We're less than 2.5 months out, and the trend is roughly in line with what we've seen in our past reporting on this. It's another month where the gun control groups together, primarily Everytown, Giffords, and Brady, have again outraised the NRA and its allies, the smaller fundraisers in the gun rights space. And so it's just sort of a continuation of a trend we've seen.
Yeah. No, I mean, it's a significant one too, because traditionally the NRA has been the real player in the gun space overall when it comes to political spending, and certainly in the gun rights movement. They still are that in the gun rights movement, but now they've been eclipsed by the gun control groups, much more so because they've fallen off than the gun control groups have, received a huge influx of new fundraising, at least from what we are seeing in the Federal Election Commission and Open Secrets. Federal Election Commission documents and Open Secrets analysis of those documents. Because we do have, as you mentioned in your piece, both Giffords and Everytown are claiming that they're going to be spending a lot more money in the election than what they've brought in through their political action committees. And to be fair, one thing to keep in mind, I guess, is that there are ways to spend money in the election that aren't going to show up in some of these Federal Election Commission reports, because these deal mostly with political action committees and super PACs, where those groups have to report what they're bringing in, what they're spending on, and there's because they are able to do more stuff that's explicitly political, right? So they can do things like endorse candidates or spend money on advocating for or against candidates, right? There's different rules about what a PAC can do versus what a super PAC can do, how much money PACs can raise versus whether super PACs can coordinate or directly donate to candidates, right? Those are sort of the different limitations. And all these major groups tend to have both a PAC and a super PAC, or a hybrid PAC, as a lot of the gun control groups have. But then also, of course, they'll have a 501c4, which can do political work. We can do advocacy work that most people would probably consider to be political. But as long as they're not endorsing candidates or spending on their behalf, that sort of thing, they're not subject to the same reporting standards as the PAC. So there's some limitation to what we can see in the public for where this money is going and how it's being spent. So that gives these gun control groups that have, like Everytown claimed, Red, I believe you reported that they're going to spend like $45 million in this election, right? But their PAC, what we can see in public records, doesn't show anything close to that, right?
Yeah, no, it's exactly right. And it's also important to point out that these are sort of lagging indicators because they're reported a month behind from where we are currently.
Yeah, actually, good point on that, because Everytown announced they were going to spend $45 million on July 30th. And so if they didn't make, like, if there isn't, if this is going to come all in as one giant donation from Michael Bloomberg or something like that, one of their main benefactor, if he does it on August 1st, we wouldn't see that in federal records until next month, until the end of September. So that, that's something to definitely keep in mind.
And that's certainly possible that could happen. I mentioned in my members piece this week, they stood up actually a new super PAC on the Everytown side that hasn't been involved in past elections, called the Demand a Seat super PAC. and they had a single lump sum $7 million infusion from Michael Bloomberg that just randomly showed up, and it wasn't available to us in our previous reporting. We've been reporting on this every single month so far.
Yeah.
And so these things can happen quickly like that. They haven't spent anything so far, so it's not that they've gotten involved in the race, but all of a sudden they have $8 million on hand in another completely different political arm that wasn't available in past reporting cycles. So these things can and do shift quickly. But yeah, certainly we have not seen $45 million, anything close to $45 million in spending from Everytown. Gifford similarly pledged to spend, I believe, $15 million. Mm-hmm. Same story there. We have not seen anywhere close to $15 million in spending. It's certainly possible that maybe they'll go on some sort of a blitz in the next 2 months, or to your point, maybe their definition of spending could be pretty broad to include maybe sort of other activities that wouldn't show up necessarily in an FEC filing. But
because you could advocate for like voter registration or general issue ads, advocating for their point of view on gun control without having to do that through your PAC or super PAC. There are ways to spend money that aren't going to show up in some of these federal reports that we follow, which are the only, so what we can rely on is what the groups say, right? And then what we can see in public records. And just because all of what they say they're going to spend doesn't show up in public records doesn't mean they're not spending it. Now that, one thing to keep in mind is the last time Everytown pledged, for instance, to spend $50 million in 2020, they just didn't do it. Now they pledged that right before the pandemic happened. So, it's possible that the funding for that dried up as the economy crashed, in 2020. But, it's just something to keep in mind. Like these groups might say something and we'll do our best to verify it, but we may not be able to verify everything until after the election. Also, like, your final FEC reports on election spending. And this is when we're going to start seeing everybody ramp up. Like the numbers we have go through July now, but election spending really starts to take hold in, August, September, October. So, for instance, the NRA, right? Just to talk about the NRA, they were, and we'll get into more details on it, but their super PAC is one of the things you detail in your reporting, and their super PAC has basically been dormant to this point. It hasn't brought in any money really, and it's just sort of sitting there not doing anything. That's not necessarily uncommon, because if you look at how they used their super PAC in the last election in 2020, the last presidential election, it didn't do much until right up at the end, because generally the way these groups operate is they have a broader plan of how they're going to use their different resources. And instead of raising money directly for their super PAC, the NRA tends to raise money through, their 501c4 or their PAC, and then transfer that money to the super PAC when it's time to spend it using independence, because that's the advantage of a super PAC. You can have big lump sum donations to it, and then it can spend an unlimited amount of money on independent expenditures, things that aren't coordinated with the campaign. And so, they've had a strategy of holding the super PAC in reserve until it's time to start spending a lot of money. And so even though they have more limited resources now, as you've shown in your reporting, they're probably still following that basic strategy, I would guess. And it's not really a big red flag that they haven't done much with their super PAC yet, because it'll be these next couple of months here when they start really using that thing.
Yeah. And I think the other thing that maybe has thrown a wrench into this particular race that we've seen maybe the groups hold off on spending as much as they have is that it was just so much was in flux this election. The candidate completely swapped, and maybe the groups sensing that there could be some shift wanted to hold off on running their attack ads against Joe Biden when Joe Biden was not the candidate anymore, or running their supporting ads of Joe Biden in the case of Everytown and Giffords and groups like that. So that's just another thing to keep in mind. And I think things will be more clear in the next month's filing as we're getting close. And obviously the candidates are settled to see just how much these groups really do plan to ramp up their spending, because to date, it's been fairly limited compared to some past elections.
Yeah, absolutely. Although I will say, of course, the other big takeaway is that the the NRA has really regressed in this election. Their political fundraising is absolutely down. They're not going to come anywhere near without some sort of miraculous turnaround in the last couple of months, which I don't think anyone is expecting. I mean, they still haven't settled out that New York case, even though the judge had a ruling back in July. They're still doing negotiations with the AG on some of the final reforms that the judge wants to see, trying to figure out if they can come to agreement. The internal fight is still going on there. In fact, I'll be in Dallas for their upcoming board meeting that's going on next weekend. So, we'll see if that produces any, major news. There've been a lot of smaller internal changes. For instance, they've switched out lawyers for the First Amendment case, their Supreme Court case where they had a unanimous victory. They now have a former U.S. Solicitor General from the law firm Jones Day representing them in that case instead of the Brewer firm. So, that's some level of change. It still seems as though from everything I've read and sources I've spoken to, there's still an internal struggle there, and that scandal is just not done yet. It's not over. There isn't a clear path to where the NRA is headed at this point. So I don't expect that they're going to have a miraculous last 3 months where they just massively increase their fundraising hauls for their PAC, because keep in mind their PAC can only raise money from NRA members, and NRA membership is way down from what it was just a couple of years ago. So that's seems to be what's holding them back, and what is going to be that's going to be a long-term project for them to build back up. And at the same time, how are the other gun rights groups doing? You looked at their totals too. Have they come up to replace this loss from the NRA?
I was going to say, you touched on two key points there. One, the membership struggles and hindering their ability to fundraise. They were actually outraised by Giffords alone this past month, which
has happened a couple times recently.
Yeah, it's happened a couple times this year, but that used to be unprecedented in past election cycles. Every now and then, collectively, the gun control groups would get a leg up, like a month or a particular race or something like that.
I think
but it never was.
Yeah,
it was never one-on-one groups. The NRA being outmatched in this month, and like you said, a couple of other previous months they were outraised. And then, to your point, it's not as though the other gun rights groups have picked up the slack. We've talked about this before. The NRA really is the big dog when it comes to being involved in politics. Certainly, other groups have sort of taken up the slack in the litigation realm, but no other PAC or super PAC is anywhere near, even in its diminished state, where the NRA's fundraising is brought in. We're talking like by a factor of 10 still at this point.
And SSF, I think, is the closest next. Yeah, and they're obviously an industry group, so it's a little bit different than the NRA. I think USCCA's PAC, which is a relatively new operation, they only report quarterly, so we don't have as much insight into them, but they seem to have raised about $100,000 a month, whereas the NRA is floating around 400 to 500,000, which is way down from when they used to bring in like 1.2, 1.3 a month in some presidential elections like 2016, right? But the alternatives aren't picking up that slack. There's nobody is making up what the NRA has lost at this point. And that's been the story the entire time the NRA has struggled, right? I mean, even look, some of these groups are not focused on this, like Gun Owners of America. They seem to focus more of their efforts on lobbying and the legal work. Like you said, a lot of these groups have their most substantial contributions have been in the legal realm, where they filed lawsuits and had victories that are, produce practical results. The political realm has not been as much of a priority for any of them. Like GOA, I think raises a couple $100 a month in their PAC. It's not a real force. It just isn't. And maybe that's because that's not what they're focused on. But nobody is making up that slack. Is the bottom line.
Yeah, no, I think those are great points, and listeners should definitely go check out the reporting, as well as if you're a member, check out the members piece, because I track some of the spending that these groups have engaged in thus far. It's like we touched on already. They haven't really ramped up to what we expect their full spending to be. They spent a little bit in donating to parties and party organizations and things like that. Mm-hmm. But listeners should check it out. Moving on to absolutely. Some of the other stories this week, we have a couple of big rulings that you reported on. One of them being another update in the saga of the federal gun ban for drug users, because we now have a federal appeals court ruling that has tossed that as applied to a particular marijuana user.
Yeah, it's actually the second time that a federal panel in the Fifth Circuit has done this. We covered U.S. v. Daniels a while back when that was first decided. That was one of the cases that's been up to the Supreme Court, or at least that the DOJ has asked the Supreme Court to take up. Similar case here, U.S. v. Paolo, I believe. I'm probably getting that wrong. I apologize.
Yeah, Paolo Connolly, I think.
Yes. Or Paolo, I think Paolo's the last name, but either way. She was arrested after an incident with her husband shot at somebody, but she was arrested and charged for essentially owning firearms and having drug paraphernalia for, weed paraphernalia, and admitting that she occasionally smokes weed. She was not intoxicated at the time she was arrested. This was a possession crime, and it stems from the federal ban on federal gun ban for drug users, right? It's something that we've covered a lot here. That's been one of the most scrutinized sections of federal law since Bruin was handed down in 2022, because it generally deals, especially these marijuana cases, with people who don't have a violent criminal record and aren't accused of committing any violence in the charges that are before the courts in these cases. And so they've had a better success rate, I think, than a lot of other defendants who've tried to use a Second Amendment defense post-Bruin to their federal gun charges. So, and that's exactly what happened here. Essentially, the panel, which actually included one of the judges from the Daniels Fifth Circuit panel, but he didn't write this opinion, but he was on the panel, and they came to basically the same conclusion, essentially that the charge for just occasional marijuana use leading to a essentially lifetime ban on gun possession was not supported by the historical record, historical tradition of gun regulation in the United States as required under the Bruin test for a modern gun regulation to be found constitutional. So they tossed her charges as applied to her. Now they did, interestingly, and this was a pretty similar conclusion to the Daniels case as well. They did find that the facial challenge to the law was inadequate, that there were essentially at least some circumstances the court could see where this prohibition could be constitutional, could fit into the historical tradition. Essentially, the one they identify, and we've seen this from several courts, is for people who are actively intoxicated while carrying firearms. And so that was because remember, if a facial challenge, you have to show that the law is unconstitutional in all conceivable applications. Whereas an as applied challenge, you just have to show that it was unconstitutional as it was applied to you as the defendant in this particular case. So that's what the court decided. They said the charges against this particular defendant for possessing firearms while also using marijuana, generally not being intoxicated at the time that she was arrested or accused of carrying a gun while intoxicated or anything like that, just generally using marijuana and owning guns, that's unconstitutional. It doesn't fit the historical tradition. However, the law itself is not facially unconstitutional because at the very least, and it doesn't mean there might not be other circumstances where it also fits the tradition, but at the very least, there's a tradition of disarming people who are actively intoxicated that dates to the founding era, because there were codes around basically militiamen not being allowed to drink while on duty, essentially.
Right.
So that dates to the founding era, and so there's a tradition of regulating that sort of behavior for active intoxication. And so, it's just another case where, at least in the Fifth Circuit, that really cements this idea that you can't charge people just for being nonviolent marijuana users. At least I don't know if this will extend to other drugs or not. We haven't seen as many federal judges who are willing to go beyond marijuana use. We have seen a couple, but the marijuana use ones seem to be more common. And so, it's not the first time this has happened, but it is something that's a bit of a trend now, especially in the Fifth Circuit. And, I mentioned earlier, right, that the Department of Justice had tried to get the Supreme Court to take interest in Daniels. They specifically tried to get them to take up Daniels alongside a couple of other cases. You wrote about this at the time. Yeah. And the court hasn't gone for it, right?
Yeah, no, well, just add it to the list of things that the court has, despite basically, pleas from the DOJ to say, please give us some clarity on this. The court has thus far said no and sent these things back. And I'm sure before long it'll come back. And I think it's going to be unavoidable, frankly, at some point for the court to weigh in here.
Because we were pretty surprised that they didn't take it up, because usually they listen to DOJ, especially when federal law has been invalidated in one circuit. And this wasn't, I guess this is an as applied challenge. It's only for the particular defendant, but obviously that will filter down to other defendants, most likely, in these circuits, and likely outside of these circuits as well. Even perhaps could help Hunter Biden, right? We've talked about this before. He's charged with, that's what he was convicted of, was this specific crime of being a drug user and owning a gun. He wasn't convicted of being actively intoxicated while possessing the gun. It was just that he had admitted to being a drug user. There was evidence he was continuing to be a drug user while owning this gun. It's the same crime, different drugs, certainly. Hunter's accused of using harder drugs, but it's a similar legal case. Of course, now he's over in the Third Circuit, so it doesn't have a direct impact, but it could. These kind of cases multiplying in the other circuits could help provide some inference to other courts. But it hasn't struck the Supreme Court as something they need to take up yet, which is a bit odd, because usually when federal law is not enforced in one circuit. Now, I guess that's the rub. It's not this isn't enjoining the Attorney General from enforcing the underlying law here. It's an as applied challenge, so it's just the stakes are a bit lower, so maybe that's why. But it seems more that this court is just not eager to take up more Second Amendment cases at this moment. Yeah, certainly. Yeah, at least for now. I still think that it's going to be inevitable at some point, but who knows when some point is with this court. And I think more of these rulings happening puts more pressure for the court to say something along these lines. Because even if they're as applied, it just continues to weaken that law and create new persuasive authority for other courts to then. Yeah, because while it may not be the court may not be enjoining the AG from enforcing this law, it still makes it way less likely that attorneys, that these the U.S. attorneys are going to actually bring these cases, because if they keep losing on as applied challenges. Certainly. But we'll stay on top of it. Obviously, this is one of the developing areas of law that we've been all over, and will continue to do so as it moves forward. And another big appeals court ruling this week, going the other way if you're a gun rights advocate, was out of the Eighth Circuit, dealing with Missouri's fairly expansive Second Amendment sanctuary law, SAPA, the Second Amendment Preservation Act. Listeners may recall our past reporting on this law. It does what a lot of Second Amendment sanctuary laws do, where it says, we're not going to devote our resources to enforcing laws we don't like, but it goes a little bit further than other Second Amendment sanctuary resolutions and laws by essentially trying to nullify federal law that the state in this case thinks is unconstitutional. And the Eighth Circuit said you can't do that. Right. And I don't know if it's a loss for certain gun rights advocates who
a certain type
tried to implement these sort of nullification laws. Because that's been we've seen that as a little bit of a trend of late. It hasn't worked because, we've already fought the Civil War, and nullification was a big part of that. It turns out you can't just as a state assert that federal laws don't apply where you live. You can do what most of these sanctuary laws have done, and that was actually one of the basic holdings of this Eighth Circuit case. Is like, yes, the federal government can't compel states to assist in enforcing federal law. Right. That was a Supreme Court case. Actually, it was an NRA case, I believe, around the Brady Act. Because early on in the Brady Act, before the National Instant Criminal Background Check system was online, the feds tried to force local and state law enforcement to do background checks for them. And there was a case called Prince, and Prince is actually still an NRA board member, a big Wayne LaPierre ally who is actually kind of famous for getting up and cursing out Wayne LaPierre opponents at NRA board meetings now. But either way, he was the namesake in a case that established that the federal government can't force states and localities to assist them with federal law enforcement. So there is the Eighth Circuit said, yes, you can do that, but you can't then go and say that the federal laws are invalid. And the big problem, a lot of these forward-facing sanctuary laws, most of them deal with things that haven't actually occurred yet. Like they basically say, if you enact, some sort of gun confiscation, mass confiscation scheme, we'll oppose that, or we won't use our resources to assist in that. And the issue with the Missouri law was that it did that, right? But it also went further and said essentially like even things like taxes on firearms and ammunition are unconstitutional and invalid in Missouri. And that implicates a lot of federal laws, even relatively uncontroversial ones like the Robertson-Pittman Act, which taxes ammunition sales to fund wildlife preservation efforts. So, it's something that immediately brought up these issues with the supremacy clause. So the Constitution has a clause that says federal law is supreme law of the land, which essentially, states can't nullify federal law. And that's basically what the Eighth Circuit ruled. It's a pretty straightforward case of like, you can make laws in states that say we're not going to cooperate with federal law enforcement. This is where, and look, it's not just a gun thing, right? The Second Amendment sanctuary movement is really a copy of the immigration sanctuary movement, where all people on the left have tried to pass ordinances and laws that say their local law enforcement won't cooperate with immigration services, right? The federal immigration law enforcement. And so, you can do that stuff. You can say, we're not going to use state and local resources on this, but you can't say that the laws are invalid. And so, it's another in a string of these things. Luckily, this time, nobody actually ended up going to jail, because the real problem with these laws, from my point of view at least, is that they have in the past led to residents being convicted of federal crimes because they believed what these state legislators said about how they'd invalidated law. This comes into play a lot with surrounding the National Firearms Act and suppressors. There was, I believe it was Kansas, if I'm remembering correctly, although Texas just tried to do this, and the Missouri law doesn't do this directly, but perhaps indirectly. They've tried to say that if you make a suppressor silencer wholly inside of Kansas or Texas, that it would be outside of the reach of the National Firearms Act, and you wouldn't have to register it or pay the tax stamp or whatever. And the problem is the state can't do that. It doesn't work that way, especially because this is sort of an old idea about an old critique of the Commerce Clause being too broad, and that Congress has power over interstate commerce, and therefore can regulate has various federal laws that are based on this concept. And so the idea here is if everything that with the suppressor is produced inside the state, it can't be regulated by the feds. The problem with this idea is the basic structure of the NFA isn't based on the Commerce Clause. It's a tax. It's based on the federal government's taxing power. So it was just kind of a bogus legal theory to begin with. Texas's their attempt at this at least said that it wouldn't go in effect until the Attorney General had sued the federal government over the NFA and won, and that case went nowhere. It got dismissed actually back in earlier this year in June. So these laws that try to nullify federal law at the state level just they haven't worked. They're not, and they're very unlikely to ever work. So it's something we've talked about a bit and followed along with. So we just want to give the latest update on what happened with Missouri. They can go back and write a more mainstream sanctuary law if they want to, right? They don't, like the court said, you don't have to use state and local resources to enforce federal law if you don't want to. Now, of course, some of these federal gun laws are uncontroversial things for most people. Gun trafficking or illegal gun sales to prohibited persons tend to be fairly popular laws. Your base level stuff that usually it's uncontroversial to cooperate with the feds on those kinds of crimes, but not always. So, that's why a lot of these, like I said, a lot of the sanctuary laws are more forward looking at potential mass confiscation or, maybe even red flag law. If there was a federal red flag law or something like that, which there isn't, but, that's usually where these things focus and Missouri just went well beyond that stuff. And they could pull it back, I think, if they want. But interestingly, the law was actually struck down totally because the court determined, these more expansive portions that leached in, that sort of bled into nullification. The whole law relied too much on those provisions for it to survive at all. So I guess they'd have to pass a whole new law if they want to keep something like that around.
Yeah, I thought that was interesting that they didn't just sever the nullification portion, but it is interesting. Like you said, it's just another example of a court sort of drawing lines around Second Amendment sanctuary laws.
Yeah. And we're going to talk more about the NFA and all that stuff. You wrote a piece just recently on, there was a federal case that struck down the machine gun or tossed charges against somebody for having illegal machine guns. And so actually I'm going to have Matt LaRosa on the show again this week to discuss that, because he actually handles some NFA cases and just trying to get figure out where things are at with the NFA and how that particular ruling does or doesn't impact the overall gun rights fight against that law, because it's obviously, especially online, one of the most disliked federal gun laws. And it's always something that gets a lot of attention in the online gun rights community, but doesn't get a lot of attention on like Capitol Hill, places like that. So the courts are kind of your main throughput for that. But we're going to talk to him because he actually does litigation on in NFA cases. So we'll get his insight on that. But we also have some good headlines this week from outside the reload. What do we got?
Yeah, so one of the first quick links we want to just briefly touch on is we officially have, at least according to the Wall Street Journal, a cert petition filed in the Bianchi case. That's Maryland's assault weapon ban case. So that is officially back before the Supreme Court. Listeners may recall I wrote a members piece a while back about this being probably the most appealing case for them to take. If they were going to take a hardware ban case, this is the best best candidate they've had thus far. And so I think all eyes will be on the court and sort of the briefing process and to see where this one goes. Obviously, this will take several weeks, if not months, before we even get a decision if they're going to take this case or not. But this is going to be one to watch. And we just wanted listeners to know that it is officially before the Supreme Court.
Yeah. And I think, it's at the final stage. So there's no further lower court action needed for the Supreme Court to take this one.
Right.
Which is, I think, to your point, why it's the best opportunity so far. Because a lot of the other ones that have come up and asked the Supreme Court to intervene, they've been at earlier stages in the fight, the preliminary injunction stage or things like that. And the court has been reluctant to accept those cases. So they don't have that barrier this time, although there is still the issue of the circuit split. There is no circuit split on this. There may never be a circuit split on this because of stuff we've talked about in the past. These laws are only get into law in more blue states, and more blue. The states that have these tend to be in more liberal districts that are more inclined to uphold modern gun regulations than other districts in the country. So you might not ever get a circuit split. It's hard to say, but yeah, it's best chance yet for the court to take this up. And clearly some of them are eager to do that. You saw Justice Clarence Thomas when they denied cert in another AR case, saying that basically the court should take this up once they get a case that's at the final stage, like Bianchi in Maryland. So we'll see.
Yeah, we'll definitely stay on top of it because it's obviously one of the bigger stories in the world of gun litigation.
This is the one that everybody wants. Everybody on the gun rights side wants them to take up.
It really is. And then the final kind of a pair of stories from the newsletter links that we want to touch on is sort of competing rulings on the topic of switchblades. So on the one hand, we have a Massachusetts state court, the state Supreme Court, just issued a ruling or striking down rather the state's switchblade ban, saying that switchblades are protected by the Second Amendment. And then you had a federal judge in California rule the opposite way. And it all had to do with their perception of whether or not switchblades count as arms, where one said they do and one said they didn't.
Yeah. So it's interesting. You got two dueling rulings on this stuff. This is why the Supreme Court really had, to your earlier point, I think, and some of the pieces that you've written, they have to come in and make some of these decisions. Even, that Clarence Thomas, not dissent, but like concur, his note on their decision not to take up the earlier AR ban case out of Illinois. This is part of what he mentioned. Like, we haven't defined what arms are, or at least not in detail. And so, it's interesting to see two courts. And now one's a state court and one's a federal court, right? But still, they're operating, I think, largely from the same set of facts and coming to the exact opposite conclusion on whether switchblades are arms. And I don't know, we'll have to see where that all ends up. But I think for the most part, we've seen courts agree that they are arms since Bruin, because there was the Hawaii case that ended up with Hawaii actually changing their laws,
right,
to allow like knives and other, even like battle axes and stuff.
Yeah, and halberds. Yeah,
yeah. There was a whole parade with Alan Beck, the gun rights lawyer out there. Won that case, and then they did like a little parade. The Associated Press actually had a piece on that this week where they had some pictures of those guys walking around. But this is just another thing that's probably going to continue to see these kinds of dueling rulings until the Supreme Court actually takes up more Second Amendment cases. I mean, that's just I guess we're kind of a broken record on this stuff, but a lot of this isn't going to be decided until they start handing down more decisions that clarify what their position is.
Yeah. And it also touches on the machine gun ban. Just, courts have been split on whether machine guns count as arms. So sort of to bring it back to your upcoming interview. So like you said, it's just calling out for Supreme Court clarification.
Yeah. And do we have one more? Or is that all we got?
I think that's the end of our newsletter links this week.
All right. I mean, we got lots more in the newsletter. People should go and check out the newsletter itself, but we don't want to drag out the news update too long. So those were the biggest highlights. There were a lot of court rulings that we weren't able to write up this week, but that were still pretty interesting. That went in both directions. So people should go and read each one of them if you want to stay up to date with absolutely everything. We have limited resources, obviously, here at the Reload, so we try to pick and choose what we're going to write based on what we're able to get to. But yeah, I don't know. You got anything fun going on this weekend?
Probably doing some more wedding planning stuff with the fiance and watching some college football because football is back. I could not be more thrilled that football is back.
You're a big college football guy?
I have become more so. I wasn't as a kid as much, but I've become so lately. And then it's nice to see the Buffaloes at CU become sort of relevant again. I know they're kind of a polarizing team across the country, but it's just as someone that remembers when CU football meant something, it's cool to see that happen again. And they played last night and they played great. And Travis Hunter is a freak of nature athlete. Played like 100 snaps on both sides of the ball, caught 3 touchdowns, 100 plus yards receiving. It's just insane video game stuff. So I'm just thrilled that college football's back.
I've never been into college football. I mean, I was when I was very young, Penn State, but I went to Messiah College, which was a small Christian school. We didn't have a football team, but so I've always been much more into pro football. But I actually did hear about Travis Hunter, weirdly enough, just from being on social media. So he had like a crazy touchdown catch, right?
He did. Yeah. He was getting mugged to the ground and he still somehow pulled in his 3rd touchdown of the night. So he's.
Yeah. Although I also remember a lot of hype around Colorado last year and then they totally fell apart, right? Because Deion Sanders is the coach, right?
He is. Yeah. That was sort of what brought all the attention. And, they got a lot of good pieces from it, but their offensive line was basically pylons last year. And so it's hard to win games when you can't stop anybody.
Yeah. Well, good luck. I mean, I got to stay, I guess, I don't know. Adding more, I do love football, but adding another layer, another night, another several nights to, especially the NFL constantly trying to expand out into every single night.
Yeah. No kidding.
It becomes a lot after a while because the Eagles start next week, right? And they start on Friday night in Brazil on a streaming channel on Peacock. So I don't know. They're already stretching me to the limit.
That is fair
with NFL stuff. But plus, the Phillies had an amazing comeback win last night against the Braves, which was very much needed because they haven't played well against the Braves. Every year it's like, I don't know, they haven't played well against the Braves. Are we going to be able to beat? And then they beat them in the playoffs. Hopefully that happens again this year because I'm sure they're going to make the playoffs. And I wouldn't be surprised if we end up seeing them again. But I don't know. Last night's comeback win, they were down 4-0, I think, going into the 6th. And then Marsh hit a 3-run home run. And then Casti hit a 2-run home run to take the lead. And then they shut him out for the rest of the game. And that was awesome. So, and that came off a Harper walk-off win against the Astros the night before. So pretty good.
I did see that. Yeah.
Pretty good 2 days in a row here for the Phillies. Hopefully they can keep up that momentum. But I'm actually going to be speaking, by the way, to a conference at the Arizona State University later today about covering guns as a journalist. So looking forward to that. I think it's like a closed session thing. So there's no link. I'll see if there's any way to get a copy of that out to our subscribers or not, but most likely not. So, but I'm still looking forward to doing it. I think it'll be a fun, different experience. And plus I get to do it from my home instead of having to go to Arizona as much as I really do like Arizona, but I don't have to go there. I will, I guess, be in Dallas next. In fact, I'll be in Dallas for the Eagles game, which is annoying, but whatever. Do what I can do. So we'll see. Maybe I'll get some barbecue and watch the Eagles beat the Packers in Brazil.
There you go.
Of all places. But I don't know. I guess that's all we've got for this week. Make sure you check out that interview podcast where we dive into what's the implications of this machine gun ruling are. That'll be out on Monday for everyone, and of course Sunday for our members, because members get things a day early here, the podcast a day early, and also get exclusive access to all these members' pieces we've been discussing, where you'll have a lot more detail to go over on, especially your piece on the election spending from the gun group so far. And of course, members are what fund the Reload. It's the only thing that keeps us going here. So we appreciate your membership dues, and that's how we can do this reporting. We're not beholden to anyone else. This is an independent publication funded by our membership. So it lets us be much more flexible and lets us keep that independent spirit. It lets us keep that independent perspective. So head over to the Reload. Oh my gosh. Head over to thereload.com today if you want to check out our membership options and come be a part of what makes this publication possible. All right. That's all we've got for you guys this week. We will see you again real soon.